Okay, and I'm going to turn off my videos to kind of make more room for the screen itself, if I can. Okay, so if you want to go to the first page. And so this is a bit about who we are. So we're the Social Justice Office of Nova Scotia Legal Aid, and we provide free legal services across Nova Scotia. We are based out of the legal aid offices at the Halifax Tower, which is in the Halifax Shopping Centre. We moved here in about December of 2019. We share space with the Family Law Office, and so coming up September will be our second year anniversary as our own separate entity. And again, we provide support across the province, however. Can you go to the next page, please? Okay. And so we provide legal information and summary advice to everyone. Our services range from, summary advice on any issue you might have relating to landlord tenancy issues, income assistance appeals, CP disability appeals, employment insurance questions. We also help people who might not need full-fledged legal services, but we may do a limited retainer for you, for example, helping you fill out documents that you might find tricky. As well, we do provide full service representation for individuals in courts and in tribunals, including resident tenancy hearings, appeals to small claims court of those decisions. In order to be eligible for full service, you would need to be financially eligible. You need to fit into our menu of services. So for example, we don't offer services in immigration law. We just don't have the funding for that. But yes, we do serve tenants. And as well, there has to be legal merit. So it has to be something that we can do from a legal perspective. Next slide, please. So in our menu of service, that's just social justice office, because as many of you may know, we do have offices that offer services in family law and in criminal law. But we also help people with CPP disability claims, both at the first application and in appealing denials of CPP disability. We also assist people who've been denied employment insurance. Income assistance appeals, that's what we do, is fighting for people who've been cut off income assistance because of allegations related to perhaps cohabitation, or who are fighting to have a special allowance recognized. Resident tenancies is something we deal with a lot, and quite frankly, it's about half our practice, about half our applications are tenants facing tenancy issues. And as well, we assist people who are looking to file applications under the Adult Capacity and Decision Making Act. So that's a relatively new act, came in about 2017, 2018, in which if an adult requires some assistance in making decisions, say perhaps because they've had a stroke or some sort of disability that affects their ability to make decisions, then a person can make an application on their behalf to be appointed as their representative to make those decisions. As well, the adult has the right to say, no, I can make my own decisions. I don't need you to make my decisions, and we help adults in relation to that. Next slide, please. So today we're going to talk about Residential Tenancies Act and tenants' rights, with a focus on evictions. Next page. So today we're going to talk about some of the basics of landlord-tenant law, and I do apologize if it's a bit too basic for some people, but there is a lot of misconceptions out there, and I see people come into my office all the time with issues that are based on misconceptions and misinformation. We're also going to talk about evictions for rental arrears and evictions for breach of statutory conditions, and I'll get into what that means later. And then what to do if there are problems. So if I have a problem with my landlord, what's my recourse? And then we're going to talk about illegal evictions, because we have a lot of issues these days with landlords forcing evictions, particularly during the COVID freeze, the eviction freeze. And even when the freeze wasn't in place, the landlords weren't able to get to Nova Scotia to make formal applications. So we saw a big increase anecdotally speaking anyway, in illegal evictions. And then we're going to talk a bit about what resources are available to tenants. Next page. So first, the basics. So the law in Nova Scotia is the Residential Tenancies Act, and that governs the law for landlord and tenant relationships, rights, and obligations. And I'm going to call it the RTA for the rest of the presentation. The point of the Residential Tenancies Act is that it's intended to protect both landlords and tenants, and also sets up the process for resolving disputes between landlords and tenants. To resolve disputes formally, I was going to touch on this very briefly because I will be referencing some of these terms. So if a tenant wants to resolve a dispute or have the residential tenancies look at something their landlord is doing or not doing, then you make an application to the Director of Residential Tenancies, which I'm going to call a Form J. That's just the name of the application. And I have a hyperlink in the slides. If you get a copy of this later, you'll be able to take a look at it quite easily. And so when you do file an application to Director of Residential Tenancies, a hearing date will be set. People will be giving dates by which to file evidence, and it will be heard by residential tenancies officers, and I'll call them RTOs for the rest of this presentation. The RTO can mediate or have a hearing. And a Form J can be filed by either a tenant or a landlord. Next slide, please. And so I want to touch base on leases. So if you're in a landlord-tenant relationship, then you have a lease, even if it's not in writing. And a lot of people think, oh, I don't have a lease, the landlord can get away with whatever. That's not accurate, okay? Next slide. And so I'm going to talk a bit about written leases. There's a standard form lease that's set out in the regulations to the RTA, and it's easy to get a standard form lease from the Access Nova Scotia's website. You know, any tenant or landlord can print one off and take a look at it, and so they know what to expect. If your landlord wants you to sign a non-standard form lease, those leases still must follow most sections of the RTA, and it cannot have sections that contradict or violate the RTA. So if your landlord has some sort of crazy lease, for example, that they want to be able to increase your rent every 6 months, that's not enforceable, okay? And so even a non-standard lease has to follow the rules and regulations set up by the Residential Tenancies Act. So next slide, please. Bear with me, I'm just going to try and move this over. Okay. So there are two kinds of written leases. You have fixed term leases and periodic leases. We typically see more periodic leases than fixed term leases. And it's important to know what kind of lease you have because they give you very different rights. Next slide, please. And so this is a part of a standard form lease. So everyone should really check their lease because people have a lot of misconceptions. There's some confusion about the language. They often are told by landlords that I'm not going to, quote, renew your lease when the landlord has no right to renew or deny a lease. The lease would continue. And so at paragraph 8 of the standard lease, which many landlords are using, it sets out very clearly you need to put in whether or not it's a periodic lease or a fixed term lease. Unfortunately, I think I blurred out some of the lines there. A fixed term lease, you see those often. Oh, can you go back one? No, next slide. Okay, so fixed term leases have a clear start and an end date. So you might sign it for September 1st, and it starts September 1st, ends June 31st. It can be renewed or extended if the landlord agrees. So in which case you would sign a new lease or set a new end date, or the tenant would continue to live there, but with consent. And if they're living there with consent, you know, paying their rent, and but they haven't signed a new lease, then you become a tenant to a month-to-month periodic lease. Next slide, please. So fixed term leases make sense for if you're a student living in an area for a term or a school year. So you don't want a periodic lease that's going to keep on going. You want to know your start date and end date because you're going to stay there for the school year. Also, if you're working from home, for example, if you live in Alberta but are coming to Halifax to work for 6 months, then a fixed term lease makes sense. We also see fixed term leases being used by landlords to impose a form of probationary period. It's a way of having an end date for a tenant if the landlord is only willing to take the tenant on for a trial basis. And so we see it if someone has a bad credit, poor references, or if they're new to the area, if they don't have, for example, credit or differences because they don't know anyone in the area, or we see a lot of newcomers, people who come from other countries who don't have a credit background, etc. And so we often see them being subjected to fixed term leases. Next slide, please. And so this, what I'll call a probationary period, it's not something that's set out in the original Tenancies Act. It's just something that the landlord's able to do because they're able to use a fixed term lease whenever they want. It is a lower risk for the landlord because it gives you a definite end to a tenancy. They don't need to show that the tenant is difficult. They don't need to have grounds to evict. And it is very much a higher risk for a tenant who wants to stay there long term. Because what happens is that a tenant will enter a fixed term lease with a landlord, for the first 6 months. And the landlord's like, we'll try it out. And if you work out, great, we'll keep you on and we'll just renew your lease. So we'll go into a more traditional periodic lease, right? And so the tenant enters it in good faith. But if there's no agreement to continue, then there is going to be an eviction. Next slide, please. And so if you're at the end of a fixed term lease and you're unable to leave, you're the tenant and you're unable to leave because, let's say, we're in the middle of a pandemic and there's no housing, the landlord can file for an order through the legal process. They file their Form J, request the hearing, and the likelihood is that they will get their order for vacant possession or an eviction. Now, sometimes the landlord doesn't go through the legal process. We see them changing locks, turning off power, bullying. It's illegal, but quite frankly, it can be effective. And in the last few months, when people were unable to file with the tenancy board because of the pandemic and everything being shut down, we did see a lot of that. Next slide, please. And so the difficulty is that, yes, the landlord is acting illegally, but if the tenant files for an RTA order, and this is something we struggle with regularly, we file Form J, but then the question becomes, what are we asking the tenancy officer to give us? Because we reached the end of the lease, so we don't have a right theoretically to stay there. If the tenant files the Form J, then they're going to risk having an order for vacant possession sooner rather than later. I think there may be some argument that, yes, there was a fixed term lease. I was supposed to be out on, let's say, May 31st, but then this pandemic happened and I should get more time. And so, again, it's going to depend on your resident tenancies officers, but it's a tricky argument to make. So that's why we do stress. We try to encourage people not to enter fixed term leases unless they absolutely have to. Next slide, please. So a periodic lease is very different. When you have a periodic lease, which is the lease we see most commonly, you have immediate security of tenor. That means that the landlord can't just change their mind and have you kicked out. It automatically renews at the end of each period. So if it's a month to month, week to week, or year to year, at the end of that anniversary date or in the month and the week, it automatically renews. The landlord does not have to agree. And we all see tenants coming in saying, oh, my landlord said he's not renewing my lease. And I look at the lease and it's a year-to-year lease. And he has to renew on that year, but it renews automatically. The landlord does not have to consent. And quite frankly, it doesn't matter if the landlord consents or not. And so if a landlord threatens not to renew your periodic lease, you can quite frankly ignore that. And if they want to have you evicted, they'll have to take other steps. Next slide, please. So unwritten leases are fairly common as well. But the reality is, if you rent, then the law applies regardless of whether or not it's set down in writing. All terms of a standard form lease, including all the protections and rules about notices, apply as if there was a written periodic month-to-month lease. And that's the same is true if you have a written lease that has finished and you're still living there by agreement, whether it be a fixed term lease or month-to-month lease. If you're there paying rent, you're a tenant. Next slide, please. So we're going to talk about providing vacant possession, which we frequently known or call evictions. So when can you be evicted? You can be evicted for rental arrears or late rent, a breach of statutory conditions or rules that are set out in the RTA, a breach of rules set out by the landlord that form part of the lease. Next slide. As well, you can be evicted if a landlord requires the unit in good faith in limited circumstances. For example, major renovations, if the landlord needs the unit for themselves or a family member in a small building. If your landlord owns a 50-unit building, the landlord can't then go to you and say, oh, I want your unit for my brother. That's not going to fly. It's if it's a small building, 4 units or less, that's when they can ask for an eviction so that they can provide that unit to somebody such as themselves or a close family member. As well, you can be evicted if the place is no longer habitable. So it's flood or it's condemned by the city. The other lesser known rule is that if a tenant is in a unit as an employee, so let's say, for example, you are hired to be a security guard or superintendent by the landlord, and the landlord provides you with housing as part of that employment contract. If the job ends for whatever reason, then you can lose your tenancy. Again, there's no strict rules on the timing of that. And sometimes it's very blurred. Sometimes you can be a tenant. If I'm a tenant that's lived in a building for 10 years and the landlord then asks me, hey, you know what, I'll give you a deal on your rent if you become superintendent and collect the rents. Well, there it's very much a gray area. And if you decide you don't want me collecting your rent anymore, I'm still a tenant. At least that's what our argument would be, because I'm still paying rent. I've been there a long time. And just because you don't want me to do this one rule doesn't mean I'd lose my tenancy. So there are gray areas there, and that's when you really should be looking to get some legal advice. So we're going to talk about, any questions, sorry, in the meantime, for the moment?
I do. Can you hear me?
Yes.
Sorry. Hi, Tammy. It's Peggy.
Hi.
Wait a minute. I'm just putting my video on. I'm not sure. It's always puzzled me why landlords can make up their own set of rules outside of the standard lease and have that be legal. The second part to that question would be, if they give you a set of rules, which I do have outside of this lease, can they change those rules at any point in time?
I do have a section on landlord rules. So if you don't mind, I would like to hold off on answering that question until we get to that page.
Sure.
Because I specifically talk about it.
Yeah, sure.
And I think I see a question on the chat. Just bear with me. If your building is condemned, pays to move in, find new. You could theoretically make an application to the tenancy board and ask for reimbursement. We haven't seen a lot of success there. It's going to depend on why it was condemned. I guess you could look at the fact that you could make the application and say, look, the landlord failed to provide a building that was fit for living. But one of the issues and one of the difficulties we find with the residential tenancies is that they are extremely practical. And by that I mean that it's very much a math exercise. So if you're asking to be reimbursed, then they're going to want to see the receipt, the cost of the move, the cost of finding a new place. They will not give you money for damages, emotional harm, the stress of losing your home, the aggravation of looking around for new places. It's very much a math issue and what the numbers are and what you can prove. So no, you wouldn't automatically get any assistance for moving if the building's condemned. You'd have to make that specific argument, talk about how the building was leading up to it being condemned, for example, the poor conditions and whatnot. So I know that's not a great answer, but it is what it is at this point. We don't have the ability right now to go after landlords in a more punitive fashion, to say, you know what, you should be fined because you let this building come down around us, essentially. Okay, and I'll talk a bit more about that later as well. We're going to talk about rental arrears. I'm going to move to the next slide. Okay, so there are two paths to eviction because of rental arrears. First way is to simply you owe money, rent money to your landlord. Okay, the second way is that maybe you pay your rent every month, you're habitually late. And that's a phrase that we're seeing pop up in discussions about the Act and in small claims court when they're appealing orders from the resident tenancy officers. So you could pay every month, but if you're paying late, if your lease tells you that you need to pay in the first of the month and you're paying on the 5th and the 10th, or if the landlord says they're having to chase you for the rent, that can form a basis for an eviction. Next slide, please. But first, right into the arrears, let's talk a bit about the basics of rent, because there's some key points I want to point out here. Next slide. So the first thing is the anniversary date. And it's important to know your anniversary date, and that's the date your tenancy started. And it applies to both the written and unwritten leases. And the reason it's important to know your anniversary date and to keep your lease if it's written is because that date is used to determine when rent can be increased and when notice of the rental increase must be given. And when I talk about rental increases, there's monetary rental increases, but there's also changes in services. Your rent included heat, for example, and your landlord has decided, you know what, I'm done paying for your heat. I want you to pay for your heat. That's treated like a rental increase. You're entitled to the same notice, which we'll talk about in a moment. Next line, please. So rent, and many of you may know this, but I'd like to emphasize it because I do hear about landlords not following this, okay? So when you first move into a place, there is no rental increase that can take effect in the first 12 months. Your landlord can't go to you and say, you know what, you're costing me more money than I expected. You know, the oil bill is too high. Yes, I know we agreed on, $800 a month, but I'm going to have to charge you $950, right? So that's not going to work. He can't do that. That would be illegal. If he wanted to increase your rent, then he would have to give you 4 months written notice before the end of your lease, meaning your anniversary date. So if it's September 1st you moved in, the following September 1st is the first time in which you would have to pay an increase in rent. And you had to give you notice for full months in advance of that date. He could tell you in January that, yes, at your anniversary date in September, your rent's going to go up, whatever the amount is. In Nova Scotia right now, there is no limit on how much your landlord can increase your rent. And that's a significant problem from my perspective, something that's very difficult when there's very limited housing to start with. We have had some success in fighting rental increases that were ridiculously high. In some cases, we've seen them use a rent increase of like $250, $300, actually $400, which were clearly being used. The increase was clearly being used as a way of getting out a long-term tenant. And so we fought it and we were successful. But it can be very difficult to fight a rent increase. You need to look at the circumstances as a whole. So for example, if your rent's going up $400 a month and no improvements have been made and no one else's rent is going up, then yes, you can say this rental increase is unreasonable and ask for the resident tenancy officer to reduce it. Next slide, please. So rent arrears, I actually see them come up for two different reasons. One is simply people simply don't have enough money, and that's a common problem, particularly for persons who are on income assistance, when the income assistance is barely enough to, alone is barely enough to cover the rent costs. But we also see it fairly frequently when someone is protesting the landlord. So they're withholding the rent deliberately. You know, I'm the tenant, I have the money, but I've asked my landlord 50 times to fix the sink, for example. He's not, I'm gonna hold on to the rent to fix the sink until he fixes the sink. Next page, please. And so when I already meet with someone who has told me that they're withholding the rent, the first thing I tell them is pay the rent. Two wrongs don't make a right, unfortunately. It's better to pay under protest than not pay at all. People who don't want a landlord because the landlord is problematic, or there's several issues with the building. Sometimes they want to pay in trust to access Nova Scotia, which theoretically is in the legislation, but they don't do it. It's been 20 years and they've not taken rent in trust. They're not set up to do that, so that's not a route. If you feel that rent should not be paid, pay it anyway. Apply to the Resident Tenancies Director through a Form J to get an order from the RTO. Okay, that way you're doing it legally. Next page, please. Okay, and so the difficulty with holding your rent is that it's not distinguished typically from rent that's late because you weren't able to pay it. And if you're 15 days late in paying your rent, then your landlord is able to give you a Form D or notice to quit. Okay, and so one tip I would give you is that if you do get a Form D, count the days and look at the dates on the Form D. We often see landlords, particularly, quite frankly, smaller landlords who might own a building or two or be renting a room. They often get this wrong because people think 15 days, they count the first day that it rent's due as day one, and that's not how we count it. So if your rent is due on the first of the month, it's not late. It doesn't count as being late until the second. And then you count 15 days, and the first date your landlord can give you Form D for late rent is on the 17th. And so that's a misconception that we see a lot, and that can help tenants. So if you do get a look at the dates, make a note of when your rent was due, and because the landlord can't rely on a Form D that's incorrect. Next slide, please. So if you do get an eviction notice, and this is any kind of eviction notice, but for Form D in particular, you have four options. The first one is to pay the rent. And if you pay it within 15 days, you're good. Pay the rent, do nothing and move out, do nothing and stay, or file a Form J. And I'm going to go through them each in detail. Next slide, please. So the option A is to pay the rent. If you pay within 15 days after the notice to quit has been served, then the Form D is voided. So you're good to go. Okay, so the landlord can't rely on that Form D or that late rent to evict you unless they make an application to say that, yes, the rent was paid, but this tenant is habitually late with the rent. They're always paying late, always having to file a Form D, and they're paying just in the nick of time, and I'm tired of it. And that can lead to eviction. Next slide, please. And please let me know if I'm talking too quickly. I do know I have a bit of a reputation for talking quickly. I blame it on being from Cape Breton. The option B is to do nothing and move out. Okay, so if you get your Form D and it tells you to be out by the 15th of the next month, you could move out if if you wanted to do that and were able to do that. In that case, then it's deemed that your termination has been accepted, that you take responsibility for it. However, you still owe for any unpaid rent. The landlord would need to apply for residential tenancies or to deal with unpaid rent, to deal with any damages there might be, just the way they would in the normal course, and to deal with the security deposit. In those circumstances, typically the security deposit would often be used to offset any unpaid rent. Next slide, please. The other option is to do nothing and stay. So if they get like a Form D or some sort of notice to quit, sometimes just a letter from a landlord, and they panic and say, landlord's going to be out by the 20th of the month. Well, those aren't enforceable. Okay, a letter from a landlord's not enforceable from a legal perspective. So if you ignore a Form D or any other kind of notice to quit, the landlord then has two options. Okay, they can file a Form J for a mediation and or hearing with the registered tenancy officers, or if it's a Form D, that is the form for the rental arrears, and the arrears were not paid, the landlord can actually file what we call a Form K, which is an application for an eviction without mediation or a hearing. And this is something tenants really need to be aware of, because they'll get this Form K, and the next thing they get is the order for eviction, and they can't get to the tenancy board to fight it. In theory, they could then appeal that order to the small claims court, but the deadlines are very tight, and in the defenses, there's not a lot of arguments you can make. So that's why if you get a Form D and are unable to pay the rental arrears in full, you need to be very aware that doing nothing can be very problematic, because the landlord can then file a Form K, which ends in him getting an eviction order more quickly. So option C is not the best option. So then there's option D, which is the next slide, please. So option D is the tenant, is you filing a Form J. Okay, so you can ask to set aside the Form D, sorry. The difficulty is that if you owe actual arrears, there really is no defense to it. And it doesn't, quite frankly, it doesn't matter how sympathetic it is or how unreasonable landlord is in not accepting payment plans, etc. If the landlord wants the eviction, the resident tenancies officers take the position that their hands are tied, that the landlord is entitled to the eviction, and it's granted. Now, the advantage of filing a Form J is that if it gets to the tenancy officer, he always gives you the option, or she always gives you the option, of having mediation before the hearing. And that time you can work out a payment plan with the assistance of the registered tenancy officers, and that can be made into an order or a settlement agreement. So the advantage of filing a Form is that it gives time to come up with the money to pay the arrears, to negotiate a repayment, or mediate it at the resident tenancy, with the registered tenancy officer assisting. But again, that depends on whether or not the landlord will agree to a payment plan. Another approach that we see sometimes is, let's say you have the arrears, it's only $500, for example, but you have claims that you can make against the landlord for example, reduction of rent. Let's say, you know what, yes, I didn't pay all my rent for June, but the landlord had the power turned off for 2 weeks, right? Give me the landlord should owe me some money for that, so we just offset it. It is a risky approach because it is based on the residential tenancy officers agreeing should owe you money, or that rental reduction. Oh,
Hi, I am so sorry about that.
Lost the slide.
I'm so sorry. My power cut in and out. Not sure what happened
That's
there.
all right. Your power?
Yeah, the power flickered. I will jump back into the presentation.
Do you want me to try? I don't think I'm considered a host for that purposes, but here we go. Good.
Does that work?
The other option of filing a Form D is that it can buy a little bit of time. Now, a little tip is that, yes, I'm seeing it. So a little tip, because you'll have a deadline, right? Because if you don't pay the rent or file a Form J within the 15 days, and the landlord can make an application for, for an order without a hearing. And so you want to avoid that. But you also don't necessarily want to file the Form J the day you get the Form D, because you're going to get into your hearing sooner rather than later, which may be not beneficial to you if you're trying to come up, if you need time to come up with the rent money. And so be aware of their timing for filing as well, right? So you want to try to file towards the end of that 15-day period if your buying time is an aspect of it. And next slide, please. All right, so we're going to talk about breach of statutory conditions lead to evictions. Next slide. Okay, so statutory conditions are conditions or rules that are set out in the statute, the legislation that is the Residential Tenancies Act. It applies to all forms of leases, written and unwritten, and whether or not it's fixed term lease or periodic lease. And they're set out in Section 9 of the Residential Tenancies Act. And they apply whether or not the rent's paid. And so I often have people coming to me saying, you know, Tammy, I've been a tenant here for 10 years. I pay my rent on time every day. You still be evicted if there's sufficient breaches of statutory conditions. And the difficulty with that part of it is that these breaches can be very subjective. It's very evidence-based. It can be based on testimony. A lot of landlords said, tenants said, and so it can boil down to what the evidence is and who the tenancy officer believes. Next slide, please. So I think I've already gone through a lot of this, but these conditions apply to all forms of leases, whether written or verbal, and it sets out the obligations for both landlords and tenants. So the statutory conditions apply to both, and there's actually ones that are specific for landlords and ones that are specific to tenants. And again, a breach by a tenant can lead to eviction, however. Next slide, please. And so the first one, bear with me, it's going to move, fix my screen a little bit because I can't see the slide. So the first condition applies only to landlords. Okay, so the landlord has a condition that must keep the rental premises in good repair and fit for habitation, and must follow any existing laws, regulations, etc., respecting health, safety, or housing. And so, and this is my talk before about asking for a rental reduction. If your place is not being kept in good repair, you can file Form J for an order of the director. And when you do that, you need to be very specific. It's not enough to say that the landlord's not making repairs, you know, place is a mess. You need to be very specific. You need to, so because the resident tenancy officer needs to know what the order should say. Should the order say that there's leaking plumbing, that there's mold that needs to be replaced, that rails need to be put on stairs, for example? And if you're asking for monetary relief, if you're asking for example, your rent to be reduced or to be reimbursed because you spent money because you had to replace a door or something, then you need to specify that amount in the Form J. If you just say, I want reimbursement, but don't specify the amount, whether it be $50, $200, or that you're asking for a rent abatement, or you need to set out that I want the rent abatement, I want my rent to be reduced by $200 a month for the next 3 months, for example. So when you do Form J, those numbers need to be in there. The tenancy officer take the position that if the numbers aren't there, if they can't look at the Form J and know exactly what amount of money you're asking for, whether it be in payment or by a rent reduction, then it can be dismissed. The view is that the landlord's entitled to notice as to how much they're asking for. And vice versa. The same thing would apply to a landlord who was asking for reimbursement or asking for payment of damages. They need to set it out in the Form J, and they need to have the evidence to back it up. Next slide, please. So condition of premises, when I talk about the landlord keeping the premises in state of good repair, we're talking about bed bugs, other pests, necessary repairs to the unit and common areas, keeping them repaired and clean, having access to water services and heating services, entry doors and windows which are broken damages. Those are just some examples that need to be taken care of. Now, there's some instances when the landlord can say, well, yes, there's bed bugs here, but I'm not responsible because I've been trying to keep bed bugs out, and this particular tenant is having garbage pile up in the home, for example. They're the ones responsible for the pests. Or the entry door is busted because there was a dispute and one tenant threw the tenant through it or something, right? And so the landlord can argue that the tenant is responsible and should pay for those damages. So it's going to depend on who is responsible. If it's general upkeep, if the landlord's not taking care of the building, though, that lies on him. Bed bugs are traditionally seen as the landlord's responsibility, and quite frankly, it's difficult to. So it's difficult to. Sorry, I'm going to distract. There's a comment here, a question here. Yeah, landlords will often try to blame tenants for bed bugs, but quite frankly, that's difficult to prove, right? Bed bugs are ubiquitous. They're everywhere in Halifax. Landlords are responsible for bringing in control and deal with it. And so a landlord cannot, to answer the question that was posted in the chat, and I'm just going to read it in case not everyone sees it. The question is, so a landlord can let a place degrade and then an eviction? Well, no, but you need to take steps early, right? You need to call 311, ask for the inspection. You need to make your application to tenants board, ask for those repairs. If the place is degrading around you and the landlord, is not doing anything about it, then you ask for the repairs and you ask for a rent reduction in the meantime, right? If the landlord is not keeping things up to par, then you shouldn't be paying the rent that you're paying necessarily. Next slide, please. The second services, and so again, this is the landlord responsibility. If a landlord provides services reasonably related to the tenant's use and enjoyment of the unit, that landlord can't end the service without proper notice or permission from the director. So for example, if your landlord is paying for the heat, the water, the power, appliances, garbage collection, laundry facilities, if that's part of your rent, then the landlord can't just change their mind and say, you know what, I'm pulling up the laundry machines and you guys have to go to a laundromat or get your own machines. They can't do that without providing proper notice. And the proper notice is the same as notice for rent. It's 4 months prior to the date of your anniversary. Now, if something happens and the landlord needs to make a change that perhaps is out if it's her control, then yes, they could make an application to the director through Form J for permission to make that change. And one thing I'm thinking of is if they're changing the heat, moving from one form of heat to another form of heat, which may impact how payments are going to be made. And that's something, though, they would need permission from the director. You'd be able to respond, and perhaps your rent could be adjusted as a result. I'm just going to check if there's a question here. So there's a very specific question. I don't think I can get into that. It's a water issue. You end up almost out with a chemical burn from touching the water. That's something I'm not. That's a very specific question. It depends on so many factors. I'm not able to get into specific legal advice. Because it's going to depend on the factors. It's going to depend on how is the landlord responsible? Was the landlord aware that there was problems with the water? Did the landlord take steps to exercise due diligence, or was the landlord ignoring a problem? And so it really is going to depend on the facts of the case, and I can't get into specific cases right now. Next page, please. Oh, so again, remove, change in services that are provided under lease or part of your lease. It requires, again, the 4 months notice prior to the anniversary date. If the landlord has changed something without providing the appropriate notice, you just come home one day and all of a sudden you find out that the laundry machines have been removed, then you can apply to the director through a Form J, have the rent lowered, or have some of the rent paid back to you. Again, if you make if you file Form J to have rent lowered or have rent paid back, retroactively, then again, you want to put the specific amount in there. I know sometimes people just want to put in, I want to rent abatement, I want my rent lowered, and they want the tenancy officer to make a determination as to the amount. You need to let them know what you're looking for. You need to specify the dollar amount. Next slide, please. And so we're going to talk next about the evictions for breach of statutory conditions. These are the ones that apply to tenants. When there is a breach for statutory condition, what happens is that the landlord can give you a notice, and typically the formal notice is a Form E. Okay, and so they can give you that notice to quit for a breach of statutory condition 3, 4, or 5. 3 is good behavior, 4 is the obligation of the tenant, and 5 is compliance with city bylaws. And that's this one we're talking about 9.2 sub 5. This is in relation to many homes that are on a land lease community. So it doesn't apply to tenants in, like, for example, apartment buildings. Next slide, please. So the statutory condition number 3 is the good behavior, and it simply says that it does apply to both landlord and tenants, but it simply states that a landlord tenant must not behave in a way that interferes with the tenant's possession or use of the unit, or the landlord's or the tenant's use and possession of the premises. And you go to the next slide, I think I have some examples there. So for example, if a tenant, and I'm going to focus on tenants because we're talking about evictions. And so if a tenant's being loud and disruptive on an ongoing basis, if they're engaged in criminal behavior, if they're abusive, intimidating, or being rude, rude behavior can actually be sufficient for an eviction if it's towards other tenants, landlords, or landlord staff, or contractors that have been brought into the building, for example, such as electricians or plumbers, etc. Okay. Tenants can also be evicted for damaging property, or if their friends, family, or visitors damage property, or they let people onto the building and damage property. Ongoing issues or significant enough an event can lead to an eviction. For example, one instance of an argument that leads to some swearing, landlord, maybe that's not sufficient. If the argument, especially if you've been there for a long time, if you've been there for a few years and you're fed up and maybe say some things they should have said, then perhaps that won't lead to an eviction. However, if you've not been there very long and there's a physical fight, an assault charge is laid, then there's a good chance that it may lead to an eviction, that an eviction would be ordered in that circumstances. Next slide, please. So the next one is the fourth obligation of the tenant is to keep the units ordinarily clean, is the phrasing that's used in the Act. And that means that, you don't have to be Martha Stewart, but you have to keep your place ordinary, clean in a normal sense, and that it's not going to attract problems, it's not going to attract pests, that it doesn't present a safety risk, okay? You're also responsible for repairing any damage caused by willful neglect, willful or negligent behavior of the tenant, or of anyone that you allow into the building or to the unit. So, as I said earlier, you are responsible for your guests. We can't say it's not, it was my brother that busted up the wall, it's not my fault. You're responsible. Sometimes agreements can be reached. If there's a guest that caused problems, you can assure the landlord that the guest is never coming back, that is a one-time thing. There's ways to kind of defend it. If it's an ongoing problem, if you're inviting friends and acquaintances to your home on a regular basis and people are partying up until 3 o'clock in the morning very loudly, then that can be a problem. Okay, next slide, please. And so examples of obligations of tenants breaches are, for example, what we call hoarding, places, if you have so much, I don't mean clutter, I'm talking about things that where the rented unit is a state where it's a safety risk, that, you can't get to fire doors, falling risks, safety risks, fire risks, that sort of thing. Any fire safety risks other such as, for example, I've seen we had an example of someone who wasn't very good with their stove and had multiple fires. And so if you're someone who is known to be falling asleep and had some low fire start in your house because you fall asleep with candles burning or cigarettes lit, if something like that happens once or twice, they can ask to have you evicted because of the risks. Again, fighting and yelling is another one that I mentioned earlier. As well, not telling landlords about problems. So you have an obligation to make sure your landlord knows that, you know what, I've seen a couple of rats around my place. I need to do something about it. Okay. And this is where I see a lot of problems. I see a lot of landlords going, oh, I didn't know about any rats. You know, bed bugs. No one told me about bed bugs. Certainly didn't know about any plumbing problems. That's why it's so important, if you can at all, to get it in writing. And don't rely on, you know, a written note that you're given to your landlord, because that's going to just disappear. If you do it in like a handwritten note, keep a copy. Okay, and you date it, and you set up the problem clearly, and then you follow it up with another written reminder. The best way to do it is to do it by email. If you have easy access to email and can correspond with your landlord regularly by email, it's the best way to do it. Texting is also helpful. It's not the best because it's harder texts get lost, they get deleted, phones get replaced. So it's not the ideal, but it's proof, especially if you get the landlord responding, yes, I know about the rats, I'm going to do something. Okay, but it's important to stay on top of those things, right? Because sometimes when you delay enforcing or fighting for your rights, that delay can work against you. Next slide, please. Okay, so we're going to talk about landlord's rules, but first I just see that there's a couple of questions, so I'm going to take a look at what those are. Okay, if a tenant breaks statutory condition, how long is the time frame for notice to quit? It depends. I don't know offhand. I don't have the form in front of me, but depends on the type of statutory condition. For a very serious one, where if there's been like a threat made against a landlord or another tenant, then it could be a 5-day notice to quit. But that being said, a notice to quit is not an order. Okay, a notice to quit is not enforceable. So the landlord can't take a notice to quit and call the sheriff and have you out. They can't legally change the locks and push you out. And so notice to quit has limited. What it is it's just notice. It's just let you know that they want you out by that particular time, and you can file a reply to have it set aside, or you can do nothing and wait to see if the landlord does anything with that. There's another question. What are the guidelines around letting tenants know about these pieces? Had a client who had a landlord that's fabricating situations. I'm a little bit confused about that question. I think perhaps because I didn't see when it popped up. It's from Aaron. Aaron, are you able to elaborate on that a bit? Okay. Oh, saying they're allowed when they weren't. That's when you take special tenancy officers, and it comes down to who can prove it, right? And so, we've had tenancy officers that say, yes, the landlord is making allegations X, Y, and Z. The landlord has no proof. We have no other tenants complaining. We don't have any letters from tenants, or we don't have tenants here backing up the landlord. And the tenant says that the landlord is making this allegation falsely because tenant called 311 for a bylaw inspection, right? So it depends on the facts of the case and what everyone can prove, quite frankly. And that's why it's important, when you get a notice like this, and if you feel the landlord is fabricating situations, you have to do a little bit of work getting the evidence, get your other neighbors, that if you're friends saying, hey, have you made any complaints about me? Or, can you write a letter saying that I'm a good, quiet neighbor, that sort of thing. So there's different ways to prove that the landlord's fabricating it. Okay, so we're going to talk a bit about landlord's rules. And so this was a question that was raised earlier. A landlord can make reasonable rules, and a breach of landlord rules can lead to eviction. Okay, but I'm going to turn to the next slide. The rules must be reasonable, and the statute, the RTA, actually sets out what that means. So the rules must be meant to promote the safety, comfort, or welfare of persons working or residing on the premises, or to protect the landlord's property from abuse. So it has to be within the confines, and they also need to apply to everyone. So the landlord can't have different rules for the person in apartment 4 than they have the person in apartment 8, for example. Next slide, please. The other thing with landlord rules is that they must provide a copy of the rules prior to signing the lease. And if they're going to change rules or add a rule, it's the same notice periods apply. So it's because it's like changing the lease or changing the rent. 4 months of written notice before the anniversary date of that particular tenant. And so, for example, sometimes I've seen landlords that kind of willy-nilly, every time they get irritated, there's a memo going out with a new rule. That's not enforceable, okay? That's why it's really important to keep track of your lease and your notice dates. And when you receive something from a landlord, if it's undated, I would write in very neatly, received on whatever date you received it on, okay? If the rule is unreasonable or conflicts with the RTA, then you can file a Form J, an application by resident tenancies, to have that set aside, okay? For example, I've seen cases in small claims court where the landlord had very specific rules about when windows should be open and should be closed, and he wanted an order saying that the windows had to be closed all the time. That's clearly unreasonable. A day when you've had a day that's hot and humid and the sun's gone down and it's starting to cool off, clearly you're probably going to want to open your windows and cool down the apartment, right? And so, landlords can make rules, but they have to follow the RTA and have to give them proper notice. And those rules can be a number, can range from rules about dealing with garbage, dealing with, pets. We see a lot of rules with pets. We have rules regarding smoking or vaping. So there really is a range of them. Next paragraph, please. So next slide. And so what happens if you have problems, okay? Next slide. So if there are problems, the place to start with is negotiating with the landlord, okay? So you need to let the landlord know that this is a problem. And again, as I said earlier, I strongly recommend that you do in writing, because I'm amazed at how often we're before the tenancy officers and the landlord saying, well, I had no idea that this was a problem. This is the first time hearing of it. And the tenant had no evidence. And in fact, the landlord might have had evidence to the contrary, saying, look, this is the only communications I have from the tenant, because they let me know when there's other problems, but not about the specific one. And so when you negotiate with the landlord, you ask for the changes or work to be done, put it in writing. Sorry about that, just turn it off, please. The other thing to do is contact municipal inspectors if you think there's a problem with the building itself or in terms of bylaws, okay? Because if you have a problem that looks more bylaw related, then the tenancy board is not going to want to deal with it anyway. They're going to want to know that you call 311 if you have concerns about, say, the structural integrity of a deck or something, for example. They're going to want to know that you call 311 first, and they might not hear your matter until you call 311, have them deal with it. Because 311, the municipal inspectors have more power to follow up on those kinds of fixes. So if it's a dangerous deck or balcony, then the inspector can order and make an order to remedy with a deadline, follow up on it, and the town can make repairs if necessary and then charge the landlord the cost of those repairs. So they have more power to do things than the resident tenancy officers. But if you don't get anywhere, if it say it's not a problem that falls within the purview of the inspectors, then you file your application with the Director of Resident Tenancies, and that's your Form J. And at the tenancy hearing date, so you'll get a date, you will have to serve your landlord, and you will have to provide any written evidence or any hard evidence other than like your testimony in advance of that. Okay, you have to file a copy with the landlord and with the resident tenancies officer as well. So then you file with the resident tenancies officer and you give to your landlord, and vice versa. He has to also give you a copy and the resident tenancies officer a copy. And so in tenancy hearings, this always start with, do you guys want to mediate? Can we reach an agreement? I do find that oftentimes tenants can be intimidated at the hearings and through the mediation process. And so they sometimes they enter agreements that they're not comfortable with. I really encourage people to not do that, or if they feel uncomfortable attending a hearing on their own, worry about being feeling that they're being bullied into an order, then I would recommend that they contact us or Dalhousie Legal Aid or ACORN or someone else that can provide some support. And sometimes mediation's not possible, doesn't work, then you have your hearing, okay? And the hearing's fairly informal. Whoever filed the application will make their arguments first and provide their evidence first, provide any witnesses that can give some evidence on it. Then the landlord will have a chance to respond if their response. If you have lawyers, sometimes I'll make closing submissions. Often submissions aren't necessary. And then the tenancy office has 14 days to make a decision. Can you go next slide, please? So tenancy hearings these days, and even pre-COVID, so I think it was last year or two, I've been 2018, they went to telephone hearings across the province. So they're all telephone hearings, unless there's requests to do in person. And I've not seen those requests granted very often, if at all. There is no formal record. People think that the hearing's going to be recorded. It's not. Again, you have to follow your evidence in advance. And think about it, often evidence is pictures, right? And so you need to make sure that the landlord and the tenancy officer has pictures well in advance, because so often I'm aware that people will go to the hearing. And so I represent tenants at these hearings, and oftentimes there'll be a landlord on the other side who's not, who's have a long history of being a landlord, don't have legal counsel, or new to the process, and they will tell us during the hearing, but I have all my receipts here. I have the pictures here. I have all the written complaints here. And it's like, well, you didn't give it to any of us. So it's, it's not something that can be admitted. It's maybe you're too late. So it's really important to gather up that evidence, get it organized, and file it beforehand. The hearing is quite informal. If you've ever been to court, it's very different than a court hearing. Again, decision needs to be given by the end of 14 days. If you do not get the decision by the end of 14 days, it's so important to call and follow up. We've seen tenants who've come to us because they got home and there was an order of the sheriff on the door saying they had to be out in 24 hours or 48 hours or what have you, because they didn't get the decision. The hearing was months ago, but they hadn't followed up and didn't realize the decision had been rendered and that they were supposed to vacate 2 months prior. So it's really important to get the decision, even if you think it's not going to be in your favor, because you need to know what's going on and because timeframes are so important. Next slide, please. If you disagree with the tenancy officer's decision, you do have the option of filing an appeal of the order of the director with a small claims court. This must be done within 10 days of the decision, and I mean 10 calendar days, not 10 business days. That can be hard to do. So if you can't file within 10 days of the date of decision, sorry, that's the date of decision, not the date you get it. So if you don't check your mailbox very regularly, or if they're emailing to your email very regularly, and you receive the decision on July 20th, sorry, the decision is dated July 20th, but you don't see it till August 10th, then you're out of time for filing. In that case, you would need to request an order to extend the time for filing. You would need permission from the small claims court to do that. If you do file an appeal of the order of the director of small claims court, both the landlord and director of residential tenancies will have to be served by the tenant. When it goes to an appeal, it's not an appeal the way we think of a court decision being appealed. It tended to be a fresh new hearing, a trial de novo is what we call it. And so if you're the one making a claim, you provide your evidence. You don't assume that the adjudicator. So a small claims court is held by and decision made by adjudicators. They're not judges. So the adjudicator will tell you how they want to proceed. Sometimes they're very informal. Sometimes they won't even put someone on the witness stand. They'll do it all when everyone's sitting at the tables. But sometimes it's very formal. But you want to make sure you have all your evidence with you. Don't assume that what you file with the director of residential tenancies is already there. You may have additional evidence that you want to give. You may have witnesses you want to bring with you. So you want to have everything there at the hearing, and you want to have multiple copies. So let's say it's being alleged that you didn't pay your rent for June, and you're like, well, here's my receipt for June, as well as the e-transfer confirmation showing the landlord got the money. So you want a copy for the adjudicator and a copy for the landlord. I always bring an extra copy for any potential witnesses, and of course a copy for yourself. Next line, please. And so if you disagree with the small claims decision, so let's say you had your hearing under the adjudicator made a decision you did not agree with, the only route of appeal at that point is to the Supreme Court of Nova Scotia. This is very difficult. It's not a matter of, well, I disagree with the decision. And what I see a lot of, well, he didn't believe me, he believed the landlord's lies. It's like, well, that's not a grounds for argument. Because when you talk about, well, he believed someone's lies, that's what we call a question of fact. The reality is that the adjudicator believed facts that weren't in your favor, but that's his role. His role is to determine what he feels the facts are. He makes findings of facts. So the only way to get to the Supreme Court of Nova Scotia to appeal a small claims decision is to meet certain technical arguments. So you have to argue there's a lack of jurisdiction, a lack of procedural fairness, or an error in law. And those are very technical arguments. If you're looking at making an appeal to appealing a small claims decision, then you really should get legal advice, because otherwise it could be wasting a lot of time, and there are costs associated with that. If you bring a matter to the Supreme Court of Nova Scotia and lose, then that court can say, you know what, you had to pay certain costs to the landlord. The other piece of it is that while you're appealing the small claims decision, their order is in effect, okay? And so if it's an order for an eviction, you're not going to get to the Supreme Court of Nova Scotia likely till after the eviction date's passed, and you're not going to get a decision before then likely. It's a bit of a long process. But the decision is not stayed automatically. The decision is going to go forward. So while you're trying to make the technical arguments, you could have sheriffs showing up with the sheriff's order, give you notice of 48 hours, before the locks are changed, for example. And so if you do feel you have a legal argument about a small claims decision, then you would want to also file for what we call a stay of that order, and that has its own test. I'm not going to get into it right now, but that's, you want legal advice. I've only appealed small claims decisions twice, because it's so rare that we have the grounds to do it. In the first instance, we were not able to get a stay. In the second instance, we were able to get a stay. So it really depends on the facts of the case and what else is going on, and whether or not you have if you have a good legal argument. Because one of the factors in whether or not the court decides to grant a stay is that do you have a reasonable, you have an argument to make. And so that's why it's so important to talk to a lawyer, because if you don't have an argument to make, a legal argument, then you won't get your stay. You'll have no chance of getting your stay. So it's really important to get legal advice. Next slide, please. Okay, this was another, I want to talk about legal evictions for a moment, but I do see there's a couple of questions here. I'm going to take a look at that. Oh, the time frame notice to quit. It depends on what the landlord gives you, and depends on, there's so many factors on the time frame. So there's going to be links at the end of this presentation. You can take a look at that. Where was it? Oh, I cannot get into the specifics of bylaws. Municipal law is not my area of law. There are many bylaws, and it depends. Sometimes things are grandfathered, sometimes they're not. It really depends on what specific bylaw you're talking about. And how long could that process take? And I'm sorry, I did not see when that question came up. Which process are you referring to? Oh, going to Supreme Court, Nova Scotia? It depends. I think I don't recall offhand, it's either 25, 30 days to apply. Trying to think, when I did it, I think we filed in, September. We had a hearing, I think in October, to deal with the stay of the eviction. We got our stay. We had we had our final hearing in December, and yeah, so it took a few months, and that's the way. And that wasn't in Halifax. That was actually in one of the more rural areas, and so I don't know if that would be applicable here. I know sometimes the courts in rural areas are faster to get through. They just have, smaller, less on the docket kind of thing. So it really depends. But again, the question isn't, if it's about an eviction, it's not going to going to Supreme Court of Nova Scotia, appealing that order for an eviction is not going to buy you any time, if that's what you're thinking about, unless you get the stay. And sorry, I should explain what a stay is. The stay is, the order for eviction is basically kind of held. It's not put in force. The landlord can't take it and ask the sheriffs to enforce it by changing the locks, for example. So I think that's it for the questions. So illegal evictions, I'm going to talk about them because we seem to be having them a lot lately, particularly during the COVID pandemic and the state of emergency. And so, as many of you may know, the province gave out some information that they put in what we call an eviction freeze. And there was so much confusion about the eviction freeze. The eviction freeze was limited to evictions that are related to rental arrears, if the rental arrears are related to a decrease in income that is related to COVID. So for example, if I was working at a coffee shop and the coffee shop wasn't doing enough business or had to shut down completely because the COVID guidelines, I lost my job, couldn't pay my rent, then my landlord could not use that as a reason to evict me until the specified date in June, the end of June. So that was what the province had imposed in terms of the freeze. But realistically, the reality is that Access Nova Scotia also shut down. And we're only open for limited purposes. So the means to get an order for eviction was shut down. You couldn't get, a landlord could not get an order for an eviction through the Form J process we talked about, or the Form K, which is the asking for an order for eviction without a hearing because of rental arrears. They couldn't get in to file those. Access Nova Scotia, which is where you file all your applications for resident tenancies matters, only accepted matters that were emergencies. And late rent, irritating tenants, tenants staying past when there's, past a fixed term lease date, those are non-emergencies. When they were accepting emergencies, and that meant that if the tenant was out of power, or if there was some like serious risk of abuse or harm or safety. Okay, so during that period, I suspect there was a lot of evictions that happened illegally. We saw them through locks being changed by landlords. We saw utilities being shut off. We saw, I've heard about bullying and harassment by landlords and landlord staff. We also see locally, well, not just locally, across the province, what we call a rent eviction. So your landlord decided to revamp the entire building, or perhaps, as we're commonly seeing, your building's been bought by a new landlord. Yeah, you've been there for 10 years. They decide they're going to renovate the entire building and tells everyone they need to get out by then next week, and they do it without notice, proper notice, without permits, or without going through the rental tenancies process. And we also have seen landlords who literally, bully everyone out of the building. You might have one person that's sticking to their guns, they're staying there, and they're basically renovating and tearing the building down around them. So those are significant problems, and they are violations of the Tenancies Act. Next slide, please. So if you are facing a legal eviction, if it's in relation to the water being cut off, something to do with the structure of the building, you can call 311 and they can sometimes intervene. You can call police and sometimes intervene. If you've been locked out, if your tenant's been locked out illegally, the police hopefully should be able to tell the landlord that no, you can't lock out the tenant without an order and get you back in. Sometimes, unfortunately, depends on who you're talking to at that particular time. The other thing to do with a legal eviction is file a Form J with or without legal assistance. And of course, I would always recommend legal assistance. Next slide, please. But where it gets a bit tricky is because, as I mentioned before, the rental tenancies process is very practical, and it's not set up to impose penalties or fines on bad landlords, okay? So if you're already out, if you were constructively evicted, meaning you were forced to move because the place was falling down around you through renovations, because the landlord kept turning off the power or the water to do those renovations, bullying, whatever the case might be, yeah, in theory, you could file a Form J and make the complaint. But then the question becomes, well, what's the remedy? What are you asking the tenancy board to order? And that's where it gets really tricky. It's like, are you asking for costs related to a sudden relocation? Sure, you can do that. You need to keep those receipts and improve it. Are you asking for a rental reduction retroactively because of the inconvenience of having such short notice that the last month you living there was problematic? That's one possibility. Someone just asked when the meeting ended. I do apologize. I guess I'm running a bit late. It's 1:30. I just a few more slides so I can wrap up. Or Sydney, are you there?
I am here. Yeah. If you're okay to continue, I'm fine to keep going. And then if there are people who, have to leave or for whatever reason, yeah, we can.
Okay, sure. Yeah. So, and I don't think it'll be much longer anyway.
Mm-hmm.
And so, yeah. And so and the other issue too is if you're out of the unit, okay. And so let's say you somehow get this award because the landlord made your life for the last few months living there, living hell, pardon my language. And the tenancy officer agrees, yes, you know what, you should get those 3 months rent back. So you have an order for 3 months rent, so maybe it's $1,500, maybe it's $3,000. How do you get the landlord to pay that? That's very tricky. It costs money to get that money, and not just costing money because you had to go through a process of enforcement. I'm not going to get into those details now, but you also need the information, right? Landlord, where does the landlord bank? Do you have the account number? Do you know where they live? Like, there's so much information you need to get that money. So it's very problematic. Next slide. So as I said, the RTA does not give resident tenancy officers or the small claims court the power to order fines, penalties, general damages. So if you feel, like for psychological, emotional harm, they don't make awards for that. So, landlords, if there's an illegal eviction or bad behavior, the remedies are very limited. And if just for bad behavior, if you have a landlord that's problematic, bad behavior, typically what you'd be looking for is a termination of the tenancy. It just means that the landlord gets rid of a tenant that they're maybe abusive to or bullying. So, which is not a satisfactory outcome for the tenant. So we need to look at something different. Next slide. So how do we hold bad landlords accountable? Is there another option? And this is something that we've been turning our mind to lately. In the Written Tenancies Act, and I know this is a bit technical, but I just want to make sure everyone's aware of this, and I think we need to share the information on this, that there are two provisions in the Written Tenancies Act that provide for summary conviction proceedings against landlords, okay? And so I've highlighted here, Section 23 of the Written Tenancies Act, the offensive penalty is telling us any person who violates or fails to comply with the order, direction, or requirements of the director or small claims court, or contravenes the act, or any landlord who takes action against a tenant because of any resort by the tenant to any governmental authority, such as bylaw inspection, in relation to securing his rights or in relation to the premises. And so in theory, a landlord can be charged and convicted of an offense that's punishable in summary conviction and liable to a fine of not more than $1,000, which isn't a lot. But if every tenant, if there's 30 tenants that make up 30 offenses, then it can add up. Now, unfortunately, Section 24 provides that no proceeding for summary conviction can be brought without a consent of the Attorney General. So the Crown needs to be involved. The reality is that I've not seen this section used. I don't think it's something that we can't do it privately. Typically, it's something it's a charge. It's like almost like a traffic offense or a provincial offense. The police need to lay the charge. And I'm quite frankly, I'm not sure that police are particularly aware of this section. So I think it's important for tenants and tenant advocates to point out that, yes, okay, my landlord's locked me out, my landlord's X and Y. I want to make a formal complaint under Section 23 of the Act, right? And so we need to kind of start making that movement. It's my understanding through just conversations kind of through the grapevine is that this section has only been used once against a landlord. I won't say who it is, but he's someone who's considered a quote slumlord, and he was found guilty. So I think there's value in educating tenants and tenants advocates, and for us organizing and pushing for this section being used on basis when people are being evicted on a large scale basis, for example. It's not going to be used for small complaints, for example, but certainly when you have, and we all know about these landlords that are evicting entire buildings because they want to change the building from lower income to higher income, and they're not giving people notice and not going through the legal processes, and that's when this act should be used. This section should be used, in my view. And there's another section I'd like to draw your attention to. Turn the page. Section 1216. So this is actually kind of interesting. And Section 12, it's a long section, right? This is only the 16th provision of that one section. It's all about security deposits. And so Section 23 is a section that gives the summary conviction offense punishable of a fine not more than $1,000. If a landlord violates the section in relation to security deposits, the potential for the fine increases to $5,000, which is quite significant, which makes sense because I'm aware that there are some landlords out there that are charging massive amounts for security deposits. They're charging full month's rent, and they're, as a matter of course, not giving it to anyone. They're not returning any damage deposits, and they're not following orders to return damage deposits. And typically, the individual tenant does not have the means to enforce it. So we need to be asking for our peace officers, for community officers to be prosecuting under Section 1216 16 of the RTA. Next slide, please. So these summary eviction proceedings, you know, they're not done through Form J. They're not done through the resident tenancy officer or small claims, just no jurisdiction. In my view, we need to start building those relationships with the community police officers and ask them to make the formal complaint on Section 23 or in relation to security deposit Section 12. And come see us at Legal Aid, because it's something that we're very interested in looking at the options for. Next line. So resources. Before I get into the resources, because that will be quick, there are some questions here. I think I've answered those questions. So the resources are there's just some here. These are ones dealing with evictions rather than housing. There's lots of people that can support you in finding housing, but Nova Scotia Legal Aid, we're here. You can apply to your local office either by calling your local office or going to our website, www.nslegalaid.ca, and all these links on this slide are clickable. We also have an online chat every Wednesday from 3 to 5 on social justice issues, so landlord tenancy issues, income assistance issues. We do also have an online chat I'll start out there on Tuesdays and Thursdays from 3 to 5. That's about family law, if you have any family law questions. Access Nova Scotia website is actually another good resource. They have many booklets on residential tenancy questions, including the forms, notice periods. They have handy charts on the notice periods, how to count when you should give notice that you want to leave premises, that sort of thing. As well, the Legal Information Society of Nova Scotia is a fantastic resource, a fantastic website. They have online chat. You can talk to them on the phone. You can send emails. And there's just a lot of information on the website itself, including a tremendous amount of information geared on residential tenancy rights on their website. A lot of it that was provided by Dalhousie Legal Aid Service, which is the next resource I'm going to mention. You can contact them. They do help people. They provide assistance to tenants. And as well, I've just added a link to a guide to small claims courts in case you ever find yourself appealing a Residential Tenancies Act decision or in a small claims court for other reasons. And lastly, next slide. ACORN, our host, sometimes the best advocacy is through organization. As mentioned, they're the largest tenants in Nova Scotia, fighting for the rights of low and moderate income tenants and workers, and their email and number is there. And so, sometimes you help your building get organized, and sometimes it's the organization and the advocacy that helps get landlords' minds changed or get the legislation changed and action happening better than any kind of litigation can. So, and I think that's it. Any questions? Yep. We're a bit past time. If there's some quick questions, I don't mind answering them, but I do have to go shortly. I have people waiting on me. Oh, yeah, so someone just commented, what needs to happen is to get rent control here. Yes, I absolutely agree with that. And that's something that people need to advocate for through their politicians. And I think when we're advocating for rent control, I think, because there's certain, it needs to be the political will. And I think we need to emphasize that it's not just about the tenants, but the rent control can help everyone, right? Because it's better for communities to have everyone stably housed. It's better for people's mental health, physical health. It's just better all around. It's better for businesses. It's better for, if I'm not spending all my money on rent and have money to actually spend on local businesses, then it's better for the economy as well. So there's arguments that can be made, I think, from all ends of the political spectrum.
Absolutely. And ACORN has been leading the fight in Nova Scotia for rent control for the past 8 years. So if you're interested in fighting for that, reach out, get in touch with us, because we are mobilized and fighting for that. And I'll put my contact information in the chat as well.
Yeah. So I'm just looking at the comments here. No, the statutory conditions don't just apply to many homes. There are a set of statutory conditions that relate only to many homes, meaning that like there's a section 9.1 that applies to everyone, and there's 9.2 that's specific to land lease communities, what we used to call trailer parks, just because there's different issues that come up, right? If your party manager is giving you threatening to give you notice to quit, there's very little you can do about that. I'm not sure what you mean by common balcony door. If it's not a fire regulation issue, I don't see it being a problem. I don't know why it would be a bylaw issue. The landlord may have a reasonable rule about it. For example, if it has to do with heat regulation, temperature regulation, that sort of thing. Again, it's really hard to, oh yeah. Well, yeah, it could be that, certainly, especially for, this time of year. It could be, like for example, in June, you don't want your doors open because you don't want the June bugs getting in. Yeah, so there may be other reasons for it. So it's going to depend on whether it's reasonable and why, and whether or not there can be a compromise. Okay, I think I'm going to have to wrap up, but that's okay, Sydney.
Absolutely. Thank you so much for running this workshop. Really, really appreciate you coming out and dedicating a Saturday to this.
No problem. Thank you for inviting me. I was happy to do it.
Of course.
And feel free to send people our way anytime. And there's so many misconceptions out there. So we're always glad to be able to get out there to give some people some information, especially about Form J's and withholding rent and all this stuff that gets tenants in trouble. So it's better to get those things nipped in the bud.
Absolutely.
So I hope everybody has a good Saturday and the rest of the weekend.
Okay. Thank you very much. And I'll be posting the slides and the recording right after this.
Okay, thank you.
Okay, thanks everyone.
Bye-bye.